Good day to my lecturer. My name is Fatin Nabila binti Ismail. Today I will be presenting for the course INC500 Industrial Relation, Regulation and Cybersecurity. My presentation focuses on the landmark case of Heidy, Quah, Gaik, and Kerajaan Malaysia 2025, which was heard in the Court of Appeal Putrajaya. This case is a significant milestone for the freedom of expression and its intersection with regulation in Malaysia. Let's look at the background. The appellant is Heidy Quah Gaik, a human rights activist and the founder of Refugee for the Refugees. A respondent is Kerajaan Malaysia. The incident occurred in June 2020 during the COVID-19 pandemic and the movement control order. Heidy posted on Facebook regarding the poor condition and the spread of the virus within Immigration Detection Center. Her purpose was clear: to highlight humanitarian concern and urge public health risks. Because of that post, she was charged under Section 2331A of the Communication and Multimedia Act 1998 (CMA). The government-elect her comments were offensive and made her the intent to annoy. Looking at the procedural history, the Session Court initially granted her a DNAA. However, Heidy decided to challenge the constitutionality of Section 233 itself. While the High Court dismissed her challenge, she appealed to the Court of Appeal, while ultimately led to the landmark judgment we are discussing today. There are several key legal issues here. The first one is whether the term offensive and annoy in the CMA are unconstitutionally vague. Second, whether criminalizing speech based on this term violates Article 10 of the Federal Constitution. Third, whether these restrictions are actually reasonable or proportionate under the interest of public order. Most importantly for our course, we must consider the industrial relation angle. Thus the existence of such regular law create a chilling effect on workers, union leaders or activists who want to report workplace malpractice or government labor policies. So the Court of Appeal's reasoning was very clear. They found that offensive and annoy are based purely on subjectivity. What annoys one person may not annoy other. Because of this vagueness, the law fails to provide fair notice to citizens of what constitutes a criminal. The court also noted that there are no link to public order, as merely annoying someone doesn't threaten national security. Crucially, they pointed out that under Section 233, there is no offensive of the truth. Even if a statement is 100% true, a person could still be charged just being annoying. In terms of constitutional principle, Article 10 establishes that freedom of speech is the rule, while restriction is the exception. The court applied a third-part test for a restriction to be valid. It must be legitimate, necessary, and proportional. The court ruled that Section 233 failed this test. It acted as a blanket restriction that was far too wide, catching legitimate, truthful speech in its net. Now let's critique this from an industrial relation perspective. This judgment strongly supports whistleblower protection. Workers can now speak out about unsafe conditions just like Heidy did, without the immediate fear of a criminal charge. It also protects trade union power. Trade union leaders often annoy employers or the government during industrial disputes. This ruling prevents the law from being used as a tool to silence their disputes. Ultimately, it encourages accountability and transparency in the workplace. Evaluating in this case, the strengths are clear. It strengthens human rights and aligns Malaysia with international standards while removing a draconian tool of silence. Of course, there is a potential challenge, a legal gap where malicious harassment might escape punishment until a more specific law is drafted. However, my stance is that this judgment is a victory for democracy. Constitutional right must take precedence over the government desire to avoid being annoyed. So to conclude, Heidy, Quah and Kerajaan Malaysia is a landmark case that successfully challenged the overreach of the CMA 1998 by striking down offensive and annoy. The court has fortified the marketplace of idea. Its true significance lies in ensuring that activists, workers, and citizens can hold authorities accountable without without the threat or at of arbitrary criminal prosecution. So these are the reference used for my research, including the primary case law, the federal constitution, and legal analysis from Article 19. Thank you for listening, and I am happy that you listen to my presentation. Thank you.